Welcome. I am Carol Oast. Let me take my share screen off, excuse me. Welcome. I am Carol Allman-Morton, the Executive Director of OLLI at BCC. We are so delighted to have you here tonight and to welcome back Dr. Tom Gerety. Dr. Gerety taught constitutional law through most of his career. He retired as Collegiate Professor of Law and Humanities at NYU. He headed up the Brennan Center for Justice and was president of both Trinity and Amherst Colleges. He has law and philosophy degrees from Yale. We are so grateful to Tom for raising his hand and offering to help us navigate understanding all of this news in the last week. I'm going to make just a few announcements and then we'll get rolling. You can see a list of upcoming events on the OLLI website, and I'm going to put the link in the chat. And I encourage you to save the date for the fall 2023 OLLI at BCC open house for our fall 2023 courses. In-person classes will have an in-person open house. That will be August 22nd at 12:30 p.m. in person at BCC. And here is the link to register. And all of our classes that are on Zoom will have pre-recorded intros, like a little mini Zoom that will be shared by a link on August 22nd. You don't need to register for that. We'll just send it out to everybody on our mailing list. The fall semester begins September 18th and registration will open on August 23rd. And just as a note, as we get started, please put questions in the chat. Our moderators, Alan Gelb and myself, will get to as many as we can. But for now, I'm going to turn it over to Tom Gerety.
Thanks so much, Carol. And thank you all for joining us to talk about what seems to be, by the number of you who have joined in, a very passionately felt issue. This is, of course, the big indictment. The others pale in relation to it, and we're going to start out with a couple of things. I want to thank Judith Weiner, who's doing the technical stuff with a lot of savvy about the substance as well tonight. And Judith is going to show a couple of things as we start. This indictment, I think I ought to say at the outset, of course, is long expected, but possibly many of us thought maybe it would never come because it might be decided that there was to be no prosecution at this by the special counsel. It's curious in one regard that I want to mention at the very outset, and that is there are now 78 counts or charges against former President Trump, 40 of which have been laid in the classified documents case down in Florida and before Judge Cannon, 34 of which were charged in the New York falsifying business records payoff or payola thing to keep Stormy Daniels quiet, and which Alvin Bragg charged heavily with many details, sort of throwing in everything to the kitchen sink in order to get Trump on that. And only 4 of which are charged by Jack Smith, special counsel Jack Smith. I'm just to show you the Washington Post. I'm going to show you, it's backwards, you can't see it, but it's extraordinary to see the number 4 and the little line in the graph. Here, I see some people leaning in, Karen Levine. Can you see that? The little line is the 4 backwards, I think, on the screen, given that it has a mirror function, and 40 and 34. I'm just an amazingly, this is a very simple, straight ahead indictment. And to honor its the study and feeling and conviction that is behind it, I think we ought to start with the actual announcement, which is only 2.5 minutes long. And Judith, would you run, it says, Judith, would you run that? So here's Jack Smith in a room in the big room at the Justice Department. You see the flag.
Good evening. Today, an indictment was unsealed, charging Donald J. Trump with conspiring to defraud the United States, conspiring to disenfranchise voters, and conspiring and attempting to obstruct an official proceeding. The indictment was issued by a grand jury of citizens here in the District of Columbia, and it sets forth the crimes charged in detail. I encourage everyone to read it in full. The attack on our nation's capital on January 6th, 2021, was an unprecedented assault on the seat of American democracy. As described in the indictment, it was fueled by lies. Lies by the defendant targeted at obstructing a bedrock function of the U.S. government, the nation's process of collecting, counting, and certifying the results of the presidential election. The men and women of law enforcement who defended the U.S. Capitol on January 6th are heroes. They are patriots and they are the very best of us. They did not just defend a building or the people sheltering in it. They put their lives on the line to defend who we are as a country and as a people. They defended the very institutions and principles that define the United States. Since the attack on our Capitol, the Department of Justice has remained committed to ensuring accountability for those criminally responsible for what happened that day. This case is brought consistent with that commitment, and our investigation of other individuals continues. In this case, my office will seek a speedy trial so that our evidence can be tested in court and judged by a jury of citizens. In the meantime, I must emphasize that the indictment is only an allegation and that the defendant must be presumed innocent until proven guilty beyond a reasonable doubt in a court of law. I would like to thank the members of the Federal Bureau of Investigation who are working on this investigation with my office, as well as the many career prosecutors and law enforcement agents from around the country who have worked on previous January 6th investigations. These women and men are public servants of the very highest order, and it is a privilege to work alongside them. Thank you.
And then he strides out in this, and it's a very sober and, as with the indictment, a very straight ahead, unadorned presentation of what he's doing, this bedrock, as he says, of American democracy, the voting. I noticed a quote from Tom Stoppard, the English playwright, which is, it's not the votes that it's not the voting that's important in democracy, it's the counting. And that's certainly at the heart of this conspiracy to, if you will, trump the actual counting and turn it into fraud. I want to give due credit to the new defense lawyer that Trump has. I mean, he seems to have an endless succession of them, and they don't last long any more than the people in his office. So I'm going to ask you to show John Lauro on the Sunday shows yesterday, telling us, basically telegraphing his defense. But before I do, I want to say, have you noticed, as in so many instances, Trump has emphasized looks and little aspects of personality that he means to pick on in people who are opposing him. In the case of Jack Smith, he's accused him of looking strange, like a ghoul, crazy, et cetera, et cetera. And I just want to offer to you my own aesthetic impression of Jack Smith, and that is that he looks a lot to me like Abraham Lincoln, a lean, serious, somewhat craggy guy trying to do the right thing. And Judith, can I ask you now to show John Lauro's Sunday show compendium from the Washington Post?
If you're going to talk about the law, you have to understand what the First Amendment says and what it stands for. And all of the examples in this indictment are core political speech. Every single thing that President Trump is being prosecuted for involved aspirational asks. Asking state legislatures, asking state governors, asking state electoral officials to do the right thing. In fact, even asking Vice President Pence was protected by free speech. None of that is illegal. Okay. The defense is quite simple. Donald Trump, President Trump, believed in his heart of hearts that he had won that election. And as any American citizen, he had a right to speak out under the First Amendment. He had a right to petition governments around the country, state governments, based on his grievances that election irregularities had occurred. He had every right to speak about the important issues that were taking place after the election. Certainly, Mr. Pence, his vice president, agreed with him that there were anomalies and discrepancies in the election process. And Mr. Trump had every right to petition government and enforce his First Amendment rights. That's why this indictment is an attack on the First Amendment. When it comes to political speech, you can not only advocate for a position, but you can take action. You can petition. You can ask even your vice president to pause the vote for a period of time in order to allow the states to recertify.
Which is what this indictment alleges.
People disagree all the time about constitutional points, but nobody gets indicted. These are not criminal cases. This is how the electoral system works out. Nothing is more important and sacred than political speech.
And that will be sorted out.
And you have to have the ability, even in the White House, to discuss these various political and constitutional options.
And that will be.
There was a constitutional disagreement between Vice President Pence and President Trump, but the bottom line is never in our country's history has those kinds of disagreements been prosecuted criminally. It's unheard of.
Okay, thank you, Judith, and I'm going to ask Judith to pull up the indictment in a minute. Let me just say that he's actually pretty well spoken and sounds a lot less madcap than many of Trump's more famous lawyers. We'll see how long he lasts, but the basic claim is one that I think you're all familiar with. Trump sincerely believed this. He may have done that because he had a lot of lawyers running around who were telling him to believe it and agreeing with him when he said, I believe it. And he's believed it for a long time. He's, as we know, he's anticipated this kind of supposed or pretended fraud, even when he wins elections, as he did against Hillary Clinton. And the second, and we can talk at length about his state of mind and whether there's sufficient evidence to convict him as a fraudster, as well as how can I politely say it, a BS artist. And the second thing, which is the right of a president to say what's on his mind, to preach what's on his mind, and to, in fact, ask people to assemble, to protest according to his opinions. So I think that is the fundamental defense we're going to see. And it's not one that's going to be easy for Special Counsel Smith and his aides to get around. Trump is a very strange man who does seem to sell himself, along with everybody, his followers, on many an idea that most of us would consider completely irrational. And in the face of patent facts, you all remember Groucho Marx in that funny scene in black and white saying, don't, when he, in a woman's bedroom, don't believe your lying eyes, believe what I tell you. And that seems to be the approach Trump takes to just so many things. But it's a very, I think we have to give Lauro and Trump their moment in this session we're doing, because they're going to have a defense, and we should be interested in exactly what it will be and how it might be countered. Judith, I want to ask you now to bring up the indictment, and I'm going to go through portions of the indictment with you in the audience in hopes that you can read along with me some of the salient portions of the indictment. So let's, you've got something blacked out there as if it was, Judith, can you roll this down a little bit? There are the 4 counts, and we'll talk about them in a minute. So let's look what this indictment says. It's very few words on any given page. The grand jury convened with Special Counsel Jack Smith directing it, charges that at all times material of this indictment on or about the dates and so on. The defendant, 45th president, lost the election. So he starts right out with these factual assertions. Despite that, he was determined to remain in power, an assertion about his intentions. For more than 2 months following Election Day on November 3rd, the defendant spread lies that there had been, and notice this word, outcome determinative fraud in the election, and that he had actually won. Outcome determinative is a term thrown around in law schools, and it's self-evident what it means, but in other words, enough fraud to switch the election from one side to the other, from the claim that Trump won to the fact that Biden won by far the electoral votes that he needed. These claims were false, and here's a key sentence: the defendant knew that they were false. But the defendant repeated and widely, go ahead, Judith, disseminated them anyway to make his knowingly false claims appear legitimate to create an intense national atmosphere of mistrust and anger, and to erode public faith in the administration of the election. This third paragraph is, I think, extraordinary. A prosecutor is telling us the defendant had plenty of sort of leeway and right to do some of this. The defendant had a right, like every American, to speak publicly about the election, and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to formally challenge the results through lawful and appropriate means, seeking recounts, audits, etc., challenging ballots and procedures. The defendant did pursue these lawful methods, we might say, of contesting the results. His effort to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. But number 4, shortly after Election Day, the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. And he perpetrated in this 3 criminal conspiracies. A conspiracy, one, to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government in violation of the statute 18 United States Code, which is the United States Criminal Code, section 371. And we're going to look at that in a second. Secondly, a conspiracy to corruptly, and notice in the first count, a conspiracy to defraud using dishonesty. So the first one is fraud. The second one is corrupt obstruction. A conspiracy to corruptly obstruct and impede the January 6th congressional proceeding. That's the government function that is alleged to have been impeded and obstructed by President Trump and the co-conspirators, at which the collected results of the presidential election are counted and certified, the certification proceeding, in violation of a second statute, 18 U.S.C., United States Code 1512K, and we'll look at that. And third, a conspiracy against the right to vote and to have one's vote counted in violation of a much older statute, 18 United States Code, section 241. And we'll look at that in a second. Each of these conspiracies, which built on the widespread mistrust, et cetera, targeted, and here's that one small metaphor that he throws in, a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election. And again, repeating the function. I guess I want you to notice there's nothing literary, lyrical, or elaborate. I mean, he does not resemble Lincoln in this. It's a straight ahead, here are the facts, ma'am. This is what happened. And I think even the Trumpies would have to acknowledge that he's saying it really as it happened, with simply the adjectives that fit the statutes, that it's fraudulent, that it's a lie, et cetera, et cetera. And then he gives dates in the next page about the conspiracy, which, as you can see, runs from November 14th to January 20th, which is inauguration day. It's located in the District of Columbia. These statutes suggest in their detail that trials and evidence should be heard in the area or region where the crimes were alleged to have occurred. And that's what makes the District of Columbia the proper place. The impediment and the obstruction was against Congress and against this important function of certifying the electoral count. And it happened, as you know, in the Congress of the United States. And of course, some of you will have questions about why President Trump's speech that morning, which roused up the crowd and sent them over to the Capitol building in what turned out to be an astonishingly violent and aggressive and somewhat crazed mood, why that is not in this indictment, except as kind of background, and we'll see that in a minute. What was the purpose? Well, we know that. And that's why this indictment is the big one, the one we've been waiting for. It may be simpler than the others, it may have fewer counts, but it's about the thing that all of us were shocked by, an effort by a sitting president to overturn the legitimate results of the 2020 election by using, and then they knowingly false claims of election fraud to obstruct the federal government function by which we'd have the result that was due and fair. Now, he enlisted, as you all know, a raft of co-conspirators, and we have these anonymous statements right below on page 3 of who they are. And of course, I mean, this could be a parlor game, but it's been in the paper so much that I think all of you know. Co-conspirator 1, an attorney who is willing to spread knowingly false claims and pursue strategies that the defendant's 2020 re-election campaign attorneys would not, interestingly. And of course, this is America's Mayor Rudolph Giuliani in his period of America's wild man, which seemed to be the period in which he got close to Trump, or maybe before. And there's just no doubt about this. Why are names not named, and so on? This is Justice Department policy. Some of you may remember Comey's news statement at the time that Hillary was not indicted, a very unusual statement because you're not supposed to say anything about people who are not being indicted. And that's Justice Department policy. So these guys are not named, but they're identified in, all but name. 2, an attorney who devised and attempted to implement a strategy to leverage the role of the vice president, called ceremonial here, overseeing the certification. And of course, that's former Supreme Court clerk, elderly scholar at the Claremont Institute. I mean, a shockingly wild constitutional lawyer, Eastman. And a number of you will have heard many of us say that Eastman is an astonishing villain in all this, because he spins not just lies, but theories of lies, that this is the appropriate thing to do. Co-conspirator 3, an attorney whose unfounded claims of election fraud sounded crazy. And of course, this is Sidney Powell from Texas, whom even Trump distanced himself from as this went along. 4, the Justice Department official worked on civil matters. He was Assistant Attorney General. Jeffrey Clark, hardline, right-wing person appointed to a political office in the Justice Department, and really attempted to abuse his colleagues and the whole Justice Department apparatus by trying to get them to say that fraud had occurred when they had all concluded, including the Attorney General, who himself was so supportive of Trump for so long, William Barr. All of them thought, or nearly all of them thought, this was utterly bogus. 5, an attorney who assisted in devising and attempted to implement a plan to submit fraudulent slates of presidential electors. This is Kenneth Chesbrough, who has, again, a pretty distinguished academic record, but is not a famous name to most of us. But the reason he's prominent here is because he was a key figure in the so-called fake elector scheme, which is very much at the center of the actions that made up the conspiracy. And finally, the co-conspirator that is speculated to be Boris Epstein, a political consultant who helped implement the fraudulent slates of presidential electors scheme. And people are not entirely sure that there isn't somebody else who fits this bill, because there are a number of people who worked on it. And then a restatement of the federal government function. I'm going to put that aside now and say something about the statutes. I'm going to ask Judith to put this indictment aside and look at the statutes that have been identified here, so that all of you can have a kind of a sense of what's going on legally as Counsel Smith puts this forward. Judith, can you put the statutes up from my email to you? So the first that I've listed here, and 18 United States Code, USC 371, this is the fraud one: conspiracy to commit an offense or defraud the United States, a very general conspiracy statute. If 2 or more persons conspire to commit an offense against the U.S. or to defraud the United States or any agency thereof, and the Congress is certainly a central agency in this, in any manner, for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, each shall be fined under this title or prison not more than 5 years or both. If it's a misdemeanor, the maximum punishment will be the misdemeanor punishment. Now, notice this about this 18 U.S.C. 371, the fraud. First of all, it's mostly used in money and tax issues, but it has been upheld in other offenses against elections and so on. And the point that I want to make here is to answer a question that my wife and many other people have put: what exactly is a conspiracy? Because right in here, in these two short paragraphs, you have the common law definition of a conspiracy, which has been adopted by the United States consistently for a couple of hundred years in our conspiracy statutes, both state and federal. A conspiracy is when two or more persons agree or contract, or there are various words, get together in agreement to commit an illegal act. And in this case, any offense, meaning any crime against the United States, or to defraud the United States, which is, of course, redundant. Fraud on the United States is an illegal act. So a conspiracy is 2+ persons agreeing together to break the law. However, the latter part of the sentence goes on to say, and one or more of such persons do any act to affect the object of the conspiracy, in which case they can be punished if convicted. And this is a longstanding common law requirement that for a conspiracy to get to the level of to become manifest to the extent that it can be prosecuted, there has to be at least one so-called overt act, one palpable act. If some of us are going to, I don't know, commit an act of terrorism, somebody has to get the dynamite or rent the car or get an airline ticket in furtherance of the conspiracy. If a gang of people simply sit around and chat about it and sort of have ideas about it, even agreeing, it's rare in the United States that that's sufficient for a conspiracy. And I think under federal law is never the case. There has to be an overt act. It's often not much. And in this case, Jack Smith is going to try to show us that there are a great many overt acts or acts to affect the object of the conspiracy throughout this sequence of 2 months and more. Okay, that's the first statute out of which the count defrauding the United States by these efforts is brought. And it actually applies to other things like the fake elector scheme too. The second statute, 18 U.S. Code 1512. And this one, I think, is you can see by the very title of it, tampering with a witness, victim, and informant. This is a statute which has been used to prosecute mob action where trials and prosecutions occur in particular, and somebody kills, intimidates, threatens, you better testify the way you want, or something's going to happen to your kid, or something's going to happen to you or your store, and so on. And it's a fairly lengthy portion of the United States Criminal Code, but you can see it starts right out: whoever kills or attempts to kill another person with intent to, and then moves on. Now, if you roll down here, Judith, I'll show you that there's a lot of detail here in 1512. And the detail that we are talking about is there, stop there. Actually, I could roll it back, but no, there you have it with the thing. In the case of a threat to use of physical force, the punishment is not more than 20 years. But then notice below that, whoever knowingly uses intimidation, threatens, or corruptly persuades another person, or attempts to do so. So it's not just actually persuading, but trying to persuade. And you can see the quiver spine of Vice President Pence, former Vice President Pence here, who seems in a fairly stalwart way in the days of this scheme to have resisted persuasion about his function in the Congress in certifying the election, or engages in misleading conduct towards another person with intent to, and then rolling on, influence, delay, or prevent. And here it says testimony, but there's withholding a record, document, or other objects. from an official proceeding. And again, you can be fined or imprisoned 20 years or more. And I embolden the language, whoever corruptly, and we can roll it further, Judith, and thank you for doing it. And roll further down. I want to get down towards the bottom of this thing. No state of mind need be proved with respect to the circumstance, and some affirmative defenses and so on. And I can just sort of leave there, although I'll stop at K, because it's a second count. It's another count. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. This is a very important part of Jack Smith's indictment, and it has a problem within it. Should this indictment be appealed to the circuit court in the federal circuit court for the District of Columbia and to the Supreme Court? And that is that the very title of this section of the United States Criminal Code, and certainly its application in hundreds and hundreds of cases, has not been to behavior like this, but has been to behavior essentially in relation to courtrooms and juries of tampering or trying to influence or actually bumping off prosecutors, witnesses, informants, jurors. And so there is no question but that to a lawyer like Jack Smith, this is a statute that applies to the kind of fraud that's being perpetrated and the conspiracy to do so here. But there's not much question in my mind, and we can come back to this later, that a very pro-Trump, if you will, or very reactionary judge or justice has in this section here an opportunity to at least narrow and possibly disallow some of the offenses alleged in these counts. And I know that may be shocking to you, but I want to be completely forthright about the risks in what Special Counsel Smith has done here. I think he needed this statute. I think he has lots of evidence to say it applies, but one can easily imagine Amy Coney Barrett or Gorsuch or another justice joining the reactionary members of the Supreme Court to say this statute was misapplied. It should be confined to jury tampering and the things for which the legislative history shows it was intended. And finally, Judith, let's roll down to 18 U.S. Code 241, conspiracy against rights. This is the oldest of these statutes. From 1870, it was called the force law or the enforcement law. It was meant to enforce the Civil War amendments, the abolition of slavery, the recognition of national and state citizenship in people of all, I'm afraid to say, in men of all races at that time, the 13th, 14th, and 15th Amendments, and the vote. And we all know that Reconstruction ended in the awful counting controversy of 1876, and that Jim Crow ensued, and the horrible period of quasi-enslavement and lynching and so on that continued from after the Civil War. This was one effort passed in the earlier Congress to do something about it. And for many, many years, it didn't do much at all, but it remained on the books, and it's a powerful piece of legislation for purposes like Special Counsel Smith's. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in a state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the U.S., or because of his having exercised those rights or privilege. And then notice the Ku Klux Klan or the Knight Rider language, if two or more persons go in disguise on the highway. But notice that's a specification, or on the premises with intent to prevent or hinder. So the language of conspire to injure, oppress, threaten, or intimidate is pretty general. It's then further specified as one specification. They shall be fined or imprisoned not more than 10 years, or both, fine and imprisonment. And if death results kidnapping, et cetera, aggravated sexual abuse, a term of years of life, or both, or maybe sentenced to death. So this is a post-Civil War law. It has had its seasons of disuse, and it's had in the civil rights period and up till now, in the last 50 or 60 years, it's been applied to many violations of right. And of course, the claim here by Counsel Smith is millions of Americans, as he says in the indictment, would have been denied the power of their votes and the proper counting of the electors in the Electoral College had this fraudulent and deceitful scheme in which that Trump participated in been successful and been more than what it was, which was a vain but pretty dangerous attempt to overthrow the election. Now, a little more on conspiracies, and then I'm going to open up for a minute at least to some of your questions before we keep going. Conspiracies in the language of prosecutors are often distinguished as wheel and spoke conspiracies. A wheel conspiracy has a central hub sending out directions to a number of persons doing different things in the conspiracy. To be convicted of being part of that conspiracy, you have to have known that it was a conspiracy to commit illegal acts, and you have to have participated voluntarily. But typically in a wheel, you have a boss, and a spoke, and the spokes are the people who are simply out there doing the thing. So the question here is this a wheel conspiracy in which there's a central hub, or are we talking about a whole bunch of a kind of network conspiracy? And I think the truth about this is that it's a little bit of both. Was Trump actually acting as the commander? Well, he seemed to have delegated really a lot of power to Giuliani and especially and others. The people in the Justice Department seemed to be pushing their end of the spoke, and it had a kind of secondary hub there. But there's no question that Smith is saying Trump knew what was going on, sent his minions to do it, delegated a lot of authority to them even to think about how to do it, but knew that it was going on, and that all of the co-conspirators, and no doubt many others who were involved in it, had a very good idea of what they were up to, and realized very soon that they were in defiance of the facts, that they were making up a fictional set of frauds and bad election machines and all the rest. And on the back of that, they were going to achieve this overthrow of the actual results of that election. This turns us to something that I know interests all of us perforce, because you can't get away from it, and that is Trump's mental state throughout this. Did he have what the criminal lawyers call mens rea, a guilty mind? Did he know what he was doing was wrong? Or had he sold himself so completely on the idea that the election was stolen from him that he could be said to be, as my wife says to me, maybe an insanity defense? And while I think Trump has a lot of there's a lot of diagnostic material for psychiatrists and psychologists in Trump's behavior, narcissism, sociopathy, et cetera. Smith, in the evidence here, is showing us that there was so overwhelming a body of evidence that there was not outcome determinative fraud. Indeed, that there was very little, if any, fraud in most instances, and that the machines were working, etc. The officials were doing what they were supposed to. Those two election counters in Atlanta, who were so vilified by Trump and his minions that they, had to change addresses and shut down their telephone numbers and all the rest, that they were actually just counting votes the way they were supposed to. Again and again, judges, officials, speakers of the Speaker of the Arizona House, the Speaker of the Michigan Senate, et cetera, told Trump, no, there's not really much going on here. There's nothing that would turn this election around. And again, having heard that from all sorts of people, including Pence, from the Attorney General. I mean, I can go through just everybody. Smith goes through just about everybody Trump heard it from. He heard it from the Vice President. No, he heard it from the Department of Justice staff, with one or two exceptions. He heard it from the Director of National Intelligence. He heard it from the Director of Cybersecurity, whom he promptly fired. He heard it from his own White House lawyers, including White House counsel at the time, Pat Cipollette. He heard it from campaign officials in his own campaign. We've lost. And of course, he heard no from the federal courts and from just about all the state officials. And having heard all this, he goes out and says such things as 10,000 dead voters in Georgia, 205,000 more votes than voters in Pennsylvania, 150,000 fake votes in Detroit, Michigan, 30,000 non-citizens voting in Arizona. Voting machines all over the place were supposedly tricked out and fraudulent. And the evidence that he gives in the indictment, and I'm not going to go through much of it, but we can come back to any of it, is state by state, going through the 7 states where fake electors were recruited and gotten to sign fake affidavits and so on to be sent to the Congress. And it's just an endless parade, despite the shortness of this indictment, of facts and denials being presented to Trump, and him persisting, along with his minions, to go out and say, no, we've been defrauded, no matter what, in effect, in defiance of the evidence. And that raises a question that's going to be on all of your minds, which is, how do you handle this in a court? How do you show that somebody who may even, seems to have convinced himself of this, is actually lying to himself and lying to us? So, Alan, let me open this up to some of the questions, and we'll see if we can sort of assemble this with you and Carol digesting the questions for us, because there's so many people on this, almost 500, that I'm sure you've got a lot in the chat. And to be honest, I've just been glancing at it occasionally.
All right, why don't we start with this one, Tom? Can Trump assert the quote unquote aspirational statement defense without taking the stand? And if you maybe should just reiterate what the aspirational statement defense is.
Yeah, and John Lauro put it pretty well, I felt, didn't you? In other words, imagine that I'm Trump. I go to Pence, I go to the various officers of the Department of Justice, and I say, isn't it the case? Surely you can show there was fraud. Surely that we had, the machines were hacked. And surely Detroit had a huge fraudulent vote dump. Surely Wisconsin had something similar. In other words, at every turn, there is what Laura describes as asking questions. I think that's unfair to the facts. I think the fact is Trump was asserting again and again, we've been defrauded. I won the election. I won it overwhelmingly. And the way these counts have been made is a lie. It's a big steal, to use the phrase that he used for what he purported to do, which was, I think for many of us, the biggest steal that's been sought to occur on the United States, perhaps since the Civil War. Yeah, he would defend himself by saying, I was just talking. I was talking sincerely. And the question arises, can a president, in the face of so much information and so much conversation to the effect that, sir, you have lost in Pennsylvania, sir, you have lost in Arizona, which turned out, as you know, to be a crucial count that tipped the country's electors toward Biden. Sir, I do not have the right to reject these electoral votes and put in this, throw it open to either the Congress or the fake electors coming from the 7 states in which Rudy Giuliani and others, along with Chesborough, were organizing a fake electoral scheme, fake electors. I think it's a really, really hard question. I mean, he is such a bizarre personality, but what I do see in my mind, very effective straight ahead indictment here is an effort to build up such a strong, let me call it circumstantial case, again and again and again. Information was presented by your own officers and allies that you had lost again and again and again. You turn to Arizona, you turn to Wisconsin, you turn to Pennsylvania, you turn to the federal courts, you get the same answer. There is no evidence of substantial fraud. And yet you still insist there was, and that because of that, you can obstruct, impede, and indeed throw the election over, cancel the election in effect, and have your unelected electors, your fake electors, decide with the help of a patsy Congress, decide that you've won. I think what we're going to see, Alan and others, is in this trial, in what is concededly a liberal setting, but there are plenty, there are a few conservatives running around in DC, certainly. I think we're going to see juries behaving with great earnest and trying to evaluate this. And I think that they're going to realize as they go along that the mountain of evidence that was presented to Trump and his resistance to that evidence, his starting to exclude people who disagreed with him or fire them, to bring in only people who would support his apparent conviction that he had won. I think that people on the jury are going to decide that it's just beyond belief that he was not aware of the fact that he had lost. And as you all know, when he says to Pence and it's in the indictment, you're too honest. And when Pence backs that up with notes, you're too honest to go along with me. Or when he says, I'll let the next guy take care of this, another phrase that's in here, you see these grudging and minor concessions that he had lost and that Biden had won. So I believe in an actual down-to-earth trial in DC, a jury may be convinced of this and may vote to convict. But I would say in some more philosophic mood, we're dealing with a person who seems to be a hell of a salesman to himself. He seems to sell himself on a fictional universe again and again and again. And you remember those first days of his own presidency. My crowd was bigger than the photograph showed it to be. It's just astonishing. You could call it chutzpah, you could call it what you want, but it's just the willingness to make bald-faced lies like a 3-year-old and elaborate them, keep going on them, fire people who disagree with them. It's just astonishing in an august, a person elected to an august office. So I think he's going to be convicted on this. I'd be delighted to hear from Carol and others, especially in the laity, if you think I'm wrong about that.
The other part of the question that is interesting is can you pursue that defense, that free speech defense, without actually hearing from him on the stand?
That's a very good question. But his lawyers can certainly allege the two factors. He's engaging. Certainly he has a right to engage in free speech, and he has a right, if you will, to be in error. But he launched efforts. Take that. I don't want to spend too much time on the paper here, but the count which uses the Civil War statute, the post-Civil War statute, impair the right to vote and be counted, as Jack Smith has it, using the oppression of your federally guaranteed rights. That does not require, that's simply an objective thing. Did he, in fact, attempt and conspire to take away people's votes? And there's no emphasis in the statute itself on your state of mind, and I think it's a pretty easy one to prove in that case. If he had succeeded in this conspiracy, he would have robbed an awful lot of people of their rights to have their votes counted. But there's no question that fraud, deceit, the other combined, conspire, confederate, fraudulently, corruptly, as the other statutes and counts have it, does seem to get to mens rea, to the intention to commit a crime. And I guess in many, many aspects of law, there's a kind of standard of, could any person reasonably have believed this? And unless you say he's absolutely batso and nuts, I think you're going to conclude he didn't really believe he won. He was just BSing himself and the rest of us. But it's a really hard question, Alan.
Okay.
And
Got
it's going to
another
be a tough thing for the jury. They're going to deliberate a long time on that, I think.
Given
ahead.
that the crime took place in DC, is there any chance that the case will be moved to another state? Now, I heard Lauro, the lawyer, on he was on Fox, and he said, it was so biased in DC that they should move it to a less presumably biased environment like West Virginia, which seemed pretty funny to me.
Yeah,
what do you think about
given
that?
that it kind of is a mirror image of the DC's overwhelmingly Democratic, you have an overwhelmingly Trumpist state in West Virginia, which is, of course, why we've got Manchin threatening to run independently.
To that question about the possibility of moving the venue of the trial, I'm curious also to know, Tom, how do you see the voir dire process going on here in terms of how they're actually going to screen these jurors?
Okay, so let's go back a step. I think there's very little chance that they change the venue. Were they to change, I mean, were the judges of the district court there in Washington or the appellate judges in the circuit, the DC circuit, which is a very specialized and usually even the reactionaries on the court and the conservatives are usually highly qualified. To change the venue from Washington to, say, West Virginia or Pennsylvania or anywhere else would require a kind of conviction that there can be no fair trial had in Washington for any serious case that has some political implications. And I think that would just be an outrage. The licenses say no taxation without representation. I mean, this would be really seriously pushing the idea that Washington was a place where citizens had no rights even to deliberate on a criminal charge, albeit a very important criminal charge. So no, I don't think the venue will change. Now, so I don't think we have to worry about West Virginia. On the voir dire, and voir dire, as those of you who studied French know, means to see and to say, to see what's said by the jurors. You bring the jurors in, you evaluate them. There are many psychological studies and experts who consult on all this. It's a very important part of the criminal law nowadays. I think you're going to have a tremendous effort. First of all, jurors they're going to be an ability to strike jurors just almost arbitrarily on the prosecutor and defense side. And a lot of jurors who would seem to have profiles that might convince, say, the defense of President Trump that they're liberals or very well aware of things will probably be struck. But after that, after you run out of your strikes, you're going to have to, your several strikes of jurors just on an arbitrary basis, you're going to have to show cause. And I think you're going to end up with probably a detached group of jurors who are not heavy watchers of Rachel Maddow or readers of the New York Times. But I suspect it'll be a racially diverse and probably a class and ethnically diverse jury from DC. And ultimately, voir dire can only do so much. I mean, let's just hope there's no one in there who's a Trump fanatic who sneaks in. Nor, I guess, you would hope that there's nobody who's convinced before it all begins that he's guilty. I mean, you want a fair jury. But I'm pretty confident that Judge Chutkan, who's been doing this for a number of years, is good at this. All the commentary suggests is held in very high regard as a tough judge, but one who's also no nonsense. So I think voir dire will go along. It'll be part of what takes time about this trial. And that's another question. How much time will this trial take? And as you know, my opinion of that is it's going to take a lot of time. She is not going to want to make sudden rulings or rulings without a lot of deliberation because she does not want to get reversed on appeal. She does not want him to be tried without fairness. She wants to show exemplary fairness towards the accused in this case so that there's not a lot of chinks in the armor that goes up on appeal. Not a lot of temptation to the appellate courts or the Supreme Court to reverse.
Here's an interesting one. Can the court have can the court request a psychiatric evaluation of Trump's mental status? If he were determined to be delusional and mentally unfit, could that keep him out of politics forever?
Well, I'm not exactly sure, but I'm pretty sure. I'm reasonably confident that the court, the judge, could suggest that, but if the defense lawyers and Trump do not want it, it's not going to happen. And he's not going to want it, and it's not going to happen. He would, it's like asking him to, take off his toupee or something. I mean, he would be outraged that, that you would start having him submit to psychiatric evaluations, and it would have to be in service of an insane. His lawyers would have to say, we're going to make a defense that he didn't know what he was doing, or that he was legally insane, which is a pretty special category. And it's very hard to make an insanity defense, as you may know. Carol, do you have any special questions that you're seeing there? I'd like to get a range of reaction to what people are saying.
Sure. So we have one from one of the folks you asked us to keep an eye out for, from Charles Corellis. Won't Trump claim he believed he won because he had won? In other words, isn't he going to use the trial to relitigate the whole election? He will say that the indictment begs the question over and over by saying that he had been informed, notified, etc., when in fact he hadn't been informed of the truth because what he was being told wasn't true. This trial will in that case be a disaster, throwing the country back into chaos. This will reduce the charge to interfering with the process rather than fraud, or so he hopes. And he does have millions of people behind him.
There's no doubt about the last, but this is Buddy Corellis, who's a philosophy professor from Williams, who was president of Colgate, and whom I know pretty well because, as you know, I was a college president too, at more or less the same time. Buddy is a very good analytic philosopher. You may remember his parsing in a tough way the Second Amendment for us in one of these classes some months ago. There is no question that if Trump is willing to get in the witness stand and just preach, take all questions as an opportunity to evade and to protest and so on and so forth, as we've seen in some famous trials of, say, people who are accused of terrorism or of horrendous murder or something, or just crimes, it would be really tough for Judge Chutkan to continuously bring him back. Please answer the question, yes or no, don't elaborate, etc. I don't think he'll do that, Buddy. I think he will not want to take the stand. I think he will want to take advantage of our system, which allows him to remain silent. Should he go forward, there will be so much opportunity to say, with a strong judge enforcing it, answer the question, did or did not X, Y, Z, Speaker of the Arizona House, et cetera, did or did they not tell you there was no sufficient fraud to question the electors? And I think that kind of questioning and then ultimately cross-examination will be insufferable for a Trump. So I don't think he's going to have a chance. I don't think he's going to take a chance to become one of these zealots who gets out there and just starts screaming until the judge has the bailiff shut him down. So no, I do not believe he'll be able to do that given his personality. I think he will sit there sullenly and let his lawyers do the arguing for him. He has lied a lot, as the Washington Post and everybody else has told us. And the impeachment of his veracity, of his truth-telling would be so extraordinary that I think the jury would become impatient with it and would just say, convict this son of a gun. So no, I don't think that'll happen. Carol, anything else?
Oh yeah, well, we have plenty in the queue. We're not going to get to everybody's questions, but
no, but I'm hoping you and Alan will sort of consolidate them.
Yeah. So there's some questions around the jurors and in a couple of different directions. One about you spoke to people being as the jurors are chosen, but somebody asked about the protection of the jurors' identities and sort of what that might be like for those folks and how that would work. And then also how the average person, coming onto the jury would know what they need to know in order to successfully, navigate a trial that's as complicated as this.
Good questions. Alan asked earlier before we opened up and we got on early to make sure everything was working here, that what about the move across the country to insist or argue for, to plead for an open trial with cameras and audio. And at one point, Alan said, well, what's the chance of that? And I said, I thought almost nothing, almost none. The federal courts have resisted opening up to TV, and I don't think they're going to make the move, the big move, which may come one day, on such a hallmark case, on such, arguably, gosh, I don't know. Isn't it one of the most important cases that will ever have been tried in federal courts? I mean, one of the things I've said again and again when we've discussed President Trump is that this guy is going to go, he's going to be very big in the history books. He may be very bad in the history books. Many of us would say he's the worst president we've ever had, but he's going to be big in the history books. He's one of the rare, we've had a lot of populists and proto-fascists in the country, Father Coughlin and Huey Long and others, but this guy made it into the presidency in one fell swoop from coming out of Huck's, selling apartments and so on and so forth, and golf courses. It's going to be a very big trial, and I don't think the federal judiciary, particularly in Washington, is going to have just would even consider opening it up. I just don't think that could happen. Now, as to the preparation of jurors, this is going to be a jury that's selected under a lot of pressure, and anybody who, I don't know, is an avid reader of the Nation or the New Republic or the Atlantic or something is probably going to be struck, or they're going to say, well, you have opinions, and ferret out their opinions and say that these opinions are biased against Trump. So I think you're going to have that classic thing in modern jury selection where you're picking people who you kind of say after they're picked, well, they may be good people, but they seem to have very little interest in what's going on in the larger political world. And thus, in a certain way, you could characterize them in advance as perhaps detached from law and politics, Carol. So that would be my answer there. It's just a guess, but that's my hunch.
Thank you. I have some forecasting kinds of questions for you. If you want to put on your special magic hat.
Let's get, what do they call it on 538? The Scottish betting, whatever. Yeah, go ahead.
So we have a question about, Trump has a full dance card coming up in the next year in terms of court appearances. So what do you think is going to be, in terms of actually getting all of these things in and some kind of timeline, like how is that all going to work? And do you think, and obviously, or it seems obvious that his folks would try and get things postponed as much as possible. How do you think that's all going to shake out?
Well, first of all, we have, to my knowledge, and there's more afoot in Michigan and elsewhere, but we have 2 state cases, Atlanta, which has not been filed, and New York, which has, and 2 federal cases. So let's start with the federal judges. It's my understanding that federal judges will generally, as a matter of courtesy, coordinate one with another should there be conflicts. Should they both be willing to concede that President Trump's electoral campaign for the next presidential election is such that he can only have such and such days, such and such weeks available. So I think there will be some coordination on that. There's a lot of argument in the commentariat about whether the Florida case under a judge who would seem to be favorable to Trump because of how she's ruled earlier in the searches of Mar-a-Lago, would be delayed and go later. She seems to be moving it at a reasonable rate in relation to campaigning and primaries and the eventual election. I think it's a close call, which is more complicated. My own hunch is that the gravity of the case in Washington and the number of motions and witnesses who will be called is such that it will take longer for the judge to move ahead, despite her toughness, smartness, and eagerness to get going. She's going to have a lot of motions to contend with, objecting to this, objecting to that. There will be many attempts to have what are called interlocutory appeals to the appellate courts to stop and appeal some question so it's decided by the Circuit Court of Appeals and so on. So my hunch is will go very slowly. Down in Florida, there are big questions about what secured evidence can be shown in open court. And often the government will pull back and say, well, we won't argue about this particular document because we don't want any risk that it's exposed to public and international view. But my own hunch is Florida will go quicker, that it's actually a simpler case. There are a couple of, as you know, in Nauta, his sort of valet, and Oliveira, the guy who handled the cameras and stuff down in Mar-a-Lago, they're really two important witnesses. And there's this large question that Trump is putting in his own classic way about, well, I declassified this and I declassified that, and the evidence that he in fact had not and knew he had not. I just think the Florida case is much, much simpler ultimately. And even philosophically, it's much simpler. His state of mind is much less important. Did he or didn't he bring those things down? I think the Washington case is a really important and complex case. And there's just going to be a lot of arguing back and forth. And the judge, I think, is probably going to do a good job, but it's going to take a lot of time. Now, in relation to the primaries and the election, what if all this gets going in such a way that either or both are delayed to the election? And the question arises, several of you have asked, what about appeals? Ultimately, if the jury, let's say, convicts Trump, there no doubt will be appeals. I would be somewhat surprised if the Supreme Court was willing to dabble here, and they're in charge of their appellate docket. So I would think they would turn it down, but I'm not confident of that answer. I would think if there may well be a move among 4 justices, which is all it take to bring it up to the Supreme Court, and there I am reasonably confident that Chief Justice Roberts would side with the liberals and say we shouldn't mess with this. And I think Kavanaugh would join him, but I really don't know what Gorsuch and Amy Coney Barrett would do. And of course, we have a pretty good idea at the outset of how far Alito and Thomas will go just to support Trump. So there could be an appeal to the Supreme Court that had some real effect, as I said, about the statute, and saying, well, this was for mob bosses and tax violation and so on. This was never intended to reach the president. And you could get part of the indictment thrown out and part of the conviction in that sense thrown out. Another thing that I ought to mention here, just to anticipate a question, is can he pardon himself? Let's say he wins the election. Can he pardon himself? Well, I would guess. I mean, I'm sure he would try. And then that would lead to a lot of litigation. My hunch is that the Supreme Court would uphold the president's power to pardon. There's no limit on it. And that he could pardon himself and the insurrectionists of January 6th and all his various co-conspirators if charges are brought against them eventually. Should he win this election, many of us have said it's a very, very important election, and it could be, I mean, a lot of people have spoken apocalyptically of what can happen to American democracy in a second Trump term. Well, the beginning of the apocalypse will be him just pardoning everybody, including himself.
So on a connected note, while you're working on some prognosticating for us, which I appreciate. So, okay, so let's imagine that he doesn't win the election, and then we have years of appeals and whatever happens in that realm. Let's imagine that eventually that sort of winds up. And we have a question of, how likely is it, do you think, that he would ever actually get prison time? And what would that even look like?
Well, let's assume, I think Trump is exactly my age. I mean, give or take a couple of months. So he's within some distance of 80. And if this all winds up in a couple of years, he'll be almost 80. I would expect that any sentence of President Trump under these terms would not be, first of all, I think there might well be time in jail. If he is convicted on these counts and the counts are upheld in the appellate court and the Supreme Court either does not take the case or upholds the convictions, doesn't overturn them, I would think he would get 2 or 3 years in jail. There have been newspaper articles saying that the Secret Service would have problems having a former president in jail, and so one could imagine house arrest or some such thing, tempting a judge like Judge Hutkin, who'd be the sentencing judge. He doesn't, to my knowledge, have a criminal record. I hate to say it, but on paper, he will have a record of public service by having been president of the United States, however many of us think about his presidency. I'd be surprised if it were more than a year or two of sentence, and I'd be surprised if it were more than house arrest. I don't think we're going to see him walking around in a gray or an orange suit during our lifetimes. So my hunch is that the importance of this case and of any sentence in this case, if should it be upheld, is largely symbolic. But boy, do I think it's an important symbolism that the President of the United States, that any President of the United States can be held to account, certainly after leaving office by the criminal courts. If he is elected, further criminal prosecutions are questionable. Should the statute of limitations be told till he retires from office? It's just in the wake of Nixon and Clinton and all the other claims against sitting presidents, the Justice Department policy would be that no one should be prosecuted while in office. It should be waited until they leave. The legal questions are a little unclear, but if he's reelected, I think there'll be pardons galore, and I think he won't hesitate to pardon himself.
Thank you.
Question here, that may be another discussion. Will Trump's campaign speeches put him at risk of contempt of court? And sort of going beyond that, how much right does a defendant have to discredit the trial that he finds himself in?
I think, Alan, you and many others have seen the tweet of some days ago where he said something like, if you're going after me, I'll be coming after you. Which language, if it's just tossed out into the stratosphere, could be seen as just the usual hyperbolic, menacing the gods or something. But once a jury is seated and the judge is sitting in a trial and the lawyers are arguing, I think that the contempt power of the judge will go into play, and he will be shut up, if she can at all do it, on things that might be interpreted as intimidating or threatening. And as we've just read in these statutes, there's a possibility it could be more criminal charges lodged against him. And I think in Trump's mind, he has to realize there's a good chance he won't win the next presidential election and will not have a chance to pardon anybody, including himself. So, well, anyway, that's enough of an answer there.
Okay.
Can Trump pass? I'm looking at the chat. Can Trump pass a lie detector test? I have no idea. But if he can pass it, nobody should ever be given a lie detector test. Do I think the Supreme Court will accept an appeal? I've already answered that. Could he get a different judge? I think I've answered that's like the venue change. I don't think so. I think there's going to be huge resistance to that, as putting him in a position. There are 42 more messages. What do you see there, Alan?
Do you think any of the co-conspirators will turn?
That's a great question, because it's such a fun speculation. Well, let's start with Giuliani. I think he's scared stiff and would turn if he could. I'm not sure he's worth that much to the prosecutor. His reputation is in tatters. He appears, he's not wildly crazy like Sidney Powell, but he's an unreliable character. And it's an interesting question what he could give Special Counsel Smith and his other lawyers on this. I guess he could give conversations. He'd have to turn pretty far, almost to the extent of being a spinning top. And people are going to mistrust him. He has exaggerated, lied, and so on in so many contexts in the Trump years that I think he's not a particularly valuable turn. I do think he'll probably be prosecuted separately. And of course, the non-prosecution of these co-conspirators is significantly driven, I'm sure, in Smith's mind by the need to keep this thing simple and straight ahead and keep it moving. If he brings in all these co-conspirators, the trial complexities multiply by several fold. So I think they're going to be prosecuted separately as we go along here. And whom would I think would be tried? I think Eastman would and should be tried. I think I'd bet that he will be. I'd bet Giuliani will be tried. And I think Clark will be tried, and Chesborough. Whoever the political consultant who helped implement a plan to submit fraudulent sales, sales of presidential electors or slates of presidential electors. If that's Epstein or anybody else, he will be tried, I suspect. And I mean, there'll be a lot of trials here and I think there'll be more co-conspirators who are involved in this at lesser levels. And I think some of the state attorneys general will go after some of the people in the states who were setting up to be fake electors or setting up fake electors, with the proviso that some of the fake electors, the false slates who are asserting I've been elected, I've been made an elector, I'm submitting my affidavit and my certificate and so on. Some of them are saying to newspapers, we were tricked. We were told that these papers would not be submitted unless and until a judge held that there had been sufficient fraud or whatever violations of the rules in the election, that the election was going to be overthrown. Even then, it's kind of dicey whether you shouldn't try them. But I think if that's true, that they were, bamboozled into going along with this scheme with the guarantee that it would be all very legal, they might be in a different position. I noticed somebody asking, Ellen is asking, where's Trump's daughter and son-in-law and all of this? Well, you probably read in the paper. I mean, they've been hanging way back, and now they're seeming to step a little bit forward. But I don't know if there doesn't, to my knowledge, there's nothing in here that says anything about them. And even though it's written in a kind of anonymous way with names rarely being used, their offices are not mentioned. So I don't think they're in it. Ed Lane asks if this indictment was delayed on purpose. I think this indictment, despite its terse language and its a very simple, straight ahead approach, I think this has been researched and debated intensely by the team, which is a pretty big team of lawyers, and they're pretty top-notch lawyers, starting with Smith himself. So I don't think there's been any delay. I don't think there's been any timing to this, except let's get this done as soon as we can get it done well.
On a connected note, there was a question, are there other federal criminal statutes which appear potentially applicable, but which appears that they decided not to invoke? And if so, what are they, and why do you think that they made that decision? Yeah,
I mean, I mentioned before, and I should come back as our time runs down, the incitement. So the speech on the ellipse, the famous, let's march over there, and then his arguments, which are disputed with the Secret Service drivers of the Beast, the presidential limousine, all that stuff. It looks to many of us as if Trump was very knowingly inciting what has been called an insurrection, and certainly was a violent riot and breaking into the Congress all the way into offices, into the chamber, et cetera. In other words, I think most of us who are looking at the evidence would say, he wanted this to happen, and he told them he wanted to happen, and he knew that the crowd would follow even his hints and insinuations, that he didn't have to be any more explicit than he was to rouse them and send them over there. As Liz Cheney said so eloquently, and I'm probably paraphrasing wrongly, he inflamed the crowd, he gathered the crowd, he inflamed the crowd, and he sent it on. I think there's no doubt that if some of the wilder ones had gotten their hands on a Pence or a number of the others, Congress people, there would have been, assault and violence and maybe murder. It looks to me as if, from a strictly legal point of view, he's guilty of incitement. The Brandenburg against Ohio case at the Supreme Court, which is old now, which governs the question of using speech to cause violence, says incitement and it explains what incitement is, which is telling people to do something. But in a situation in which the telling them their passions are aroused and they're very likely to do it, imminent lawless violence. And it's certainly lawless what happened to the Congress. It's certainly violent, and it could have been much more violent. So I think he is guilty of incitement, but it does fly right into the counter winds that Lauro, the attorney, mentioned, which is, doesn't a president have a right to say what's on his mind and to yell and shout about it? And in other words, the Brandenburg case is a First Amendment case. It was a Ku Klux Klan rally in a cornfield outside Cincinnati, in which they said, let's go do this and that. And they used racial slurs and so on, and ethnic and religious slurs to say who should be victimized. But the situation in that cornfield was so remote from any real violence, such a matter of just blathering on, that it was held that there was not sufficient evidence of an incitement to imminent lawless violence. Whereas in Trump's case, there was a big crowd near the Congress with a let's go get him in effect. So I think there was an incitement, but many, many people are saying, and I think I'd concede, that Smith, who's a savvy character and a straight ahead sober character, didn't want to risk it, didn't want to throw this into a big constitutional argument about the power, the right to assemble and the right to speak out. He wanted to keep it. Notice the facts that are alleged here. They're always definite assertions of fact: 20,000 or 200,000 votes, a dump of 150,000 votes, 30,000 migrants. Smith and his team have pulled out factual assertions from a whole pile of blather of opinionated assertions, like you can never trust mail-in ballots, or you can't trust machines, or you can't trust Detroit, or you can't trust Philadelphia. Those are, in other words, wherever it strayed, the Trumpist rhetoric strayed into blathering opinionatedness, Smith kind of stayed a little bit away from it and went for the false assertions as to which Trump had already been told they were false. Maybe the funniest one of which is Pence tells him, I don't agree with you. And he goes out the next day and says, Pence agrees with me, and we're going to, not in so many words, but Pence agrees with me, and I hope he'll have the courage to do what I want him to do, which is to reject the electoral votes. I think that's enough of an answer on that.
Tom, how does the free speech defense protect him against the fake electors scheme?
I don't think it protects him at all.
Yeah, it doesn't.
I mean, it's a set of conversations. This is where somebody like Giuliani or Eastman might be helpful. I don't think they will, but I don't know their characters. I have no idea. The fake elector scheme was concocted in the way conspiracies usually are, in secret, not in a bunch of tweets and speeches and, throwing about of lies out in the public on Fox News or wherever. It was concocted in meetings. And Trump made sure if you disagreed with him or you told him facts, you wouldn't be invited to the next meeting and you might get fired. And then he would meet with those guys who were the yes men and the enthusiasts. So I think that's, in some sense, the most powerful claim here. A provable claim, I should say, rather than powerful. It's a highly provable claim. It's central to the question of the transfer of power in an election. And the evidence looks pretty overwhelming to me.
Yeah. And the Trump team is really sort of setting up a smokescreen to scare all of the people on the other side. But in fact, you only need one conviction to put him in jail for quite a while.
Yeah, and I think the symbolism that I'm mentioning, the unlikelihood of his actually serving many, many years in jail, one, I don't think this is, Bernie Madoff or something. And second of all, the unlikelihood of his actually serving much time in jail, the Secret Service problem, the opportunity, the chance that he'll get house arrest or something. And just the centrality of the question, a president tried to, it's fascinating. Giuliani did this, remember, with the mayoralty race in New York. He tried to postpone it and say, oh, the election has to be set aside. And it was notable that was, the courts resisted that and he had to back down. Trump tried to set aside an election with a lot of lies And the bogus electors are at the false electors, the fake electors are at the heart of that. I think his people might have been, I don't know, they've been enthusiastic, but they might have greeted a charge of incitement from that speech in the ellipse with a kind of a delight in the close argumentation that you could do about exactly what he said and exactly how dangerous the situation was, how imminent it was, and so on. And he was constant, even though he didn't intervene and try to stop the violence at the Congress, rather, he threw in an occasional tweet about, don't be violent, or don't attack the police or something, even though he wouldn't intervene and send in troops and try to stop it. There was a kind of outrageous neglect of duty on his part to enforce the laws of the United States, combined with his usual fence, trying to have it both ways. He's an amazing character. Just an amazing character. I've said many times, I've probably said on Ollie things, I have never in my life met a person like this. Never. I mean, I consider myself to be reasonably experienced in meeting strangers and meeting odd characters and even hanging out with them. I have never met a person so full of fibs and himself and baloney as this guy. Just never. And
maybe this is a good last question. Any chance in your mind that a plea deal might be struck?
I don't read. Trump is the art of the deal. I'd say Jack Smith is the opposite of the art of the deal. He looks like a very straight ahead guy, and he's doing what they hired him to do. And Merrick Garland, who is often criticized as too quiet an attorney general, too soft-spoken an attorney general, I think did well here. He picked a tough, smart, no nonsense, no poetry, just straight ahead. Give me the facts and I'm going to prosecute him. Stay away from any big stretch here kind of prosecutor. And I don't think he's going to make deals with anybody. And I think Garland is secretly smiling about how well this is going or how strongly it's going. And yeah, there's a chance that the Supreme Court would boldly overrule something. There's a chance the jury might let him off or split the verdict. But there's huge symbolism in the trial itself. I'd give, as I think a lot of commentators have, give a lot of credit to what was done in the House on the committee chaired by Thompson and Cheney. They didn't bring forth, quote unquote, an indictment or anything, but they showed the nation, to those of us who are willing to look, just how far this scheme went. And it is a conspiracy. It was a whole lot of people supported by a shockingly large percentage of the American public, maybe a third of us, to just say the exact opposite of what had happened. Say that an election was stolen where they themselves were trying to steal it. And if there's any feature of the Trump psychology in public life, is that he's very quick to accuse others of what he himself is harboring as his own motivation. So everybody who resists him is a racist, a thief, corrupt, right? I mean, all these qualities that I think history will show were his qualities are assigned to anybody who resists him. And I guess psychologists would call that projection. He's constantly projecting his own faults on others and on other situations. So I think it's a really important trial. I think it'll be, even though we won't be able to see it on TV, in my opinion, I think it'll be a lot of fun to read about it from the reporters who no doubt will have to wait in line all night to get their seats against other reporters who want to be in there. And I think it's going to go on for a while. If he wins the election, though, it could all be tossed out, and the symbolism could be the symbolism of a vain attempt to discipline the kind of proto-tyrant that Madison and the others envisioned as wrecking our democracy. The person who rouses up a rabble of what they called faction of zealots to break down the ordinary processes of fair judgment and fair legislation and so on. So it's really, really important. That takes me to 8:30 on the little clock on a battery that I have. I don't know what, 1 minute before on Macintosh's clock. Is that where we finish up, Carol?
Yeah, I think so. I think that's a great word to end on. Okay,
and let me thank again all of those who are with us in this discussion. I'm happy to take any questions you want to send by email, tomgerety@gmail.com. And thank you to Alan, to all of you who have asked questions, and to Carol and her staff, especially Judith tonight, and everybody else. And let's watch this with the real concern of citizens committed to a fair democracy.
Indeed. Thank you so much, Tom, and thank you, Alan.
See you all soon.
Take care. Have a good night.
Good rest of the summer. Bye.
Bye.